are the target of a criminal investigation and the government is looking to prosecute you.
If you haven't already called a lawyer who practices specifically in these arenas we practice in, that's the time.
Just because you're a witness and an agent tells you you're a witness doesn't mean you don't need a lawyer.
You're a target? No, absolutely not.
Welcome to The Federal Verdict, your go-to source for everything white-collar, whether it's enforcement initiatives, how to defend yourself, what to do if you're part of an investigation. You can find your answers to all that here. My name is Marrisel Descalzo. I'm the founding shareholder at Tache, Bronis, and Descalzo.
I'm David Tarras. I'm the head of the Federal Criminal Defense Practice and Government Compliance and White-Collar Investigations at the Rossen law firm.
Welcome. Today we're going to be talking about target letters.
Target letters.
What is a target letter?
So a target letter is a scary thing for our clients, okay? And something that we have a lot of experience with, but it's serious. So let me just say that off the bat, but it's manageable. So a target letter, first and foremost, I guess before we get into the details of it, is it's a notice to a potential client or a client of ours that they are the target of a federal criminal investigation. We say target because target has a specific unique definition, right? And specific consequences as well when you're labeled as a target. And we know that there's other labels that the Department of Justice refers to potential individuals that they want to speak to or make contact with. Do you want to talk about some of those?
Yes. The government has three categories or classifications that they put people in. It's a witness, a subject, or a target. A witness means you're not in danger. They just want to talk to you. You have information. You were the witness of a crime. Typically, I'll just give an example. There's a shooting, and you witnessed, the gunshot. You're a witness. A subject is a person that the government hasn't been able to categorize. They're not sure if they could be a target. They're not sure if they are a witness. This is a dangerous place to be in because you are in the zone of unknown, and you can move up and become a target, or you can move down and become a witness. And of course, the last is the target, which you've touched on, which is you are the target of a criminal investigation, and the government is looking to prosecute you.
Sure. And just to add, with that as well, even a witness, right? There's along this spectrum, this three-pronged spectrum, you can call it. We've certainly all seen witnesses that may have been told they were witnesses, right? It's one thing for the attorney. We can confirm, talk to a prosecutor. I know you wanted to talk to my client. Are they in fact a witness? Yes, they are. But prosecutors and agents are tricky. So we always have to be careful, right? Like, say they're a witness, but still valuable to contact counsel regarding their potential exposure if the government does in fact want to speak to them. As far as a target themselves, the way I look at target is, and I think I go kind of going off the Justice Manual and how DOJ defines it and how I relate to my clients. I'd like to hear from you as well how you relay what being a target really means, is that they don't really, it's an indication by the prosecutors, by the feds, that they don't need much more from you or from other people to indict you, to charge you with a crime. Their investigation has essentially concluded or is getting there, and they have a very strong belief that if they were to go to a grand jury tomorrow, they'd have a high likelihood of success of achieving an indictment or criminal charges. Do you agree with that? What are your thoughts on that?
100%. But before I talk about that, I have to add to something you said about a witness, which was such a good point. And it's that it's true that just because you're a witness and an agent tells you you're a witness doesn't mean you don't need a lawyer.
Sure.
First of all, only a prosecutor can affirm to another lawyer whether someone is a witness, subject, or a target. And just because you've been classified as a witness does not mean you cannot move up to target or to subject. And you can also get yourself into trouble for saying the wrong thing, misrepresenting something to a federal agent. That comes with its own host of charges.
Sure.
So, very good point.
Great
Whenever
point.
you're dealing with the federal government, you always want a lawyer. And in terms of target and the way you defined it, that's exactly it. Usually my clients that are getting a target letter, it's because the government wants something from them, and that something is usually cooperation. Because it's maybe somebody that's low on the totem pole of, the investigation, or the corporation, or someone that didn't make that much money. So they believe it's someone that can easily come in. They give them a good deal, and they'll cooperate against everyone else. Those are usually the people I see getting a target letter. Now, David, do you want to tell us, how do you receive a target letter?
Different ways, right? Could come in the mail. It could be via email, and very commonly it is hand delivered by an agent to your house. Okay, so, and I'm sure they can get creative and find other ways too. But those are the three most common ways, and that's a target letter. If nothing else, we've talked in other segments, and we always talk to our clients about how, look, there's many indicators, right? You only, our clients know what they've been through, okay? And if our clients believe that there's been no indicators that they might have exposure to anything involving an investigation until the target letter, then of course, right? Then that we stand by our clients no matter what. But a target letter should certainly be a situation where, if you haven't already called a lawyer who practices specifically in these arenas we practice in, that's the time, because they'll drop that letter off, and that's a big statement on their part. So, Marisel, what, in your experience, is generally the content of a target letter?
It's usually addressed to your client. It has an address, and it oftentimes identifies, there's usually just one paragraph where it identifies the statutes or the laws that the government believes that the person is violating. And then there is a please contact agent or please contact prosecutor, schedule an appointment, or to find out more. That's usually, it's pretty simple letter. David, we've been a little bit of doom and gloom. Target letters are terrible, but have you ever been able to do something to mitigate, the consequences of a target letter? Something, in one of your cases or for one of your clients?
Absolutely, right. And this is one reason why you and I work so often together, is because traditionally and historically, target letters, someone receives them, and you'll have a lot of lawyers who may have been practicing, for a very long time and very good. They see a target letter, they go to their client and they say, "You're screwed." Okay, you better go in and you better rush in and take that plea, right? You got to hire me. We got to go sit down with them, try and cooperate. You're a target. No, absolutely not. So I've had many situations, as I know you have, and I'd like to hear some of yours as well afterwards, where a target letter is nothing more than a bluff. Okay, it can be, as much as it's an indication that they do have a strong case, it can also, not as commonly, but also be an indication that they do not have a strong case. It can be a simple bully tactic, and is the most common bully tactic. So one example that I can think of off the top of my head is a prosecutor, I won't say her name, but anyone who's in the healthcare fraud arena and deals with the strike force in South Florida for Medicare, sent a client of mine a target letter. We have a grand jury scheduled in 2 weeks. Your client, we're talking about healthcare fraud, wire fraud. I get on the phone with the prosecutor, of course, right away, as is I usually will, before scaring my client too much. Let me just call the prosecutor. We know them. Let's see what they have to say. And the prosecutor spoke as if this case was shut and dry. They had everything in the case. I go back. I speak to my client. We go through his business, everything, and we're saying, look, there's never going to be a meeting of the minds, right? They want you to come in and plead because they say you're a target and they've got you. I say, we tell them to kick rocks because you're never going to be valuable to them. You're not even remotely in a position where you would accept responsibility, nor should you feel that way. So we said to this very experienced prosecutor, which lawyers like you and I are not scared to do, and it's the right thing for our client. Thank you very much for the opportunity. Let us know. And then this was a multi-million-dollar marketing CGX, cancer genetic testing. He was a marketer, the client, and we said, thank you, but we don't think you have it. We're not coming in, and nothing. Years later, the declination and a no file and a closeout. Okay, so it does happen, and that's not the only time. Sometimes you have to, we try and guide our clients, but if the client says, I'm not coming in, then sometimes that's the right thing and we can expose them.
Yeah.
What about you?
I obviously have had many situations where I have told the government, prosecutors have kicked their heels in, I guess, and said, we're going to indict your client. My client says, I'm going to fight, and it just goes away. And then alternatively, I've had situations where my client has received a target letter, and I have gone in and told the prosecutor, slow down. We're going to make a presentation to you, and we're going to convince you that, you're wrong. And I have been successful doing that on a number of occasions. It takes the right prosecutor, obviously someone who's open-minded, but it also, takes, being honest with your client, doing an investigation, having the prosecutor agree to slow down, and really digging in, because sometimes they do have it wrong, right? The government is not always right, despite what they think.
Yep.
And it's up to us. And boy, you save a client so many collateral consequences by not forcing them to go through the whole arrest and indictment process. So, it's always a very happy client when you can, kill the investigation early on. And I'm sure you know that as well. Well, thank you.
Yeah, thanks.
Thanks for joining us today on The Federal Verdict. Like I said, I'm Marisel Descalzo. I'm one of the founding shareholders at Tache, Bronis, and Descalzo. I'm a white-collar criminal defense lawyer. I practice all over the country, defending clients, going to trial, handling investigations, compliance, and defending against False Claims Act actions. David, you want to tell us about yourself?
Absolutely, yes. Also a white-collar criminal defense attorney and government compliance. I think first and foremost, speaking for myself, and I know speaking for Marisel, we're fighters, okay? That's what we do. We fight in this arena. The government can feel very overwhelming at time, but just like that target letter can be, it can also be a lot of puffery, and it can be a lot of bullying, and we don't allow that. And we base our practices on that so our clients can have their best futures, and we hope to do that for you guys all as well. Thank you.